and sir is also a Central Council member at ADR Bar. Then we have Mr. Neeraj Grover. Sir is the managing partner at GL Law Chambers, and he is also the mediator at Samadhan, Delhi High Court Mediation and Conciliation Center. And lastly, we have Mr. Amit Saxena, proprietor of Amit Saxena and Associates. Sir is also the joint secretary at Delhi High Court Bar Association. Our moderator for the session is Ms. Mehak Rati. Ma'am is founder of ADR HOC. I would like to thank all the panelists for taking out their time to join us today. I'm sure that it is going to be a great learning experience for all the participants. Now, I would like to hand over the stage to Mehak ma'am. Ma'am, please.
Thank you so much, Tushar. I would like to thank our panelists for joining us today. Amit sir will be joining little towards the later part. But I'm a big time supporter of ADR, and there is a lot of effort, a lot of promotions being done that ADR should be the appropriate dispute resolution mechanism, considering the pendency in courts and so many other things. Now we have organized this IP summit, and this panel is being organized to understand what is the scenario of alternate dispute resolution mechanisms in resolving IP disputes, where we stand, and what is the future which is there. To begin with, there are a lot of participants who are students, there are professionals. I would like to firstly ask Jamshed sir to just give us a brief overview as to what is the scope of ADR mechanisms in IP disputes. What is your take on this? And just to kickstart the panel so that everybody is aware of where we stand. Over to you, sir.
Sure. Can you hear me?
Yes, sir.
Fine. So, yeah, since there are students as well. So as everybody knows, the term ADR, the first word was alternate. So it was supposed to be alternate dispute resolution. What it was supposed to be and what the need and necessity of the times now is something that we will come to in a minute. So essentially, we are talking about arbitration, conciliation, mediation, and any other form of resolution which happens outside the court premises. With regard to the types of IPR, we are more familiar, or rather more familiar with trademarks and copyright, but we also have patents, geographical inscriptions, and other sort of IPR related issues. And I would definitely like to bring in over here, add your from cryptocurrency, NFTs, and other things as well. And there's a reason why I am adding that here. If you see, typically what was the scenario? The ADR and IPR, they all fall currently traditionally in their various statutes. So you had the Arbitration and Conciliation Acts, which kept getting revised. You had the Trademark, Patents Act, and you had also, for example, the Designs Act for designs in say fashion, etc. And each one was supposed to act in its own space and give the ultimately justice to the parties involved in these matters. But over a period of time, when these issues went to court and when people sought sort of asking, can ADR be used in IPR? I'll very briefly just touch upon this. Typically what the courts have said, and the Supreme Court has been clarifying from time to time, they are saying that whatever, if you seek relief in rem, that means in regard to the world at large, those issues need to go to the court or the tribunal. But those which are in personam, that means which has where there are only say 2 or 3 parties of concern with the dispute, then with regard to those, the ADR and IPR is kind of permissible. Different I mean, Bombay High Court has taken a different stand. It says even if it is in rem, it's fine. You can still go. But these are conflicting judgments, and maybe this is not the right place to discuss this. But this is where it stands now. Now, I have only a couple of things to say. Essentially, I think we need a major change in the law. Let me give you a completely different example. For example, I was involved in what is now a famous case on abortion law, say 2008, the Nikita Mehta case. I mean, I'm sorry, just diversifying a little bit, but I'll make you understand what I'm trying to say. Uh, at that point of time, the say Medical Termination of Pregnancy Act said that within you could abort a fetus within 16 weeks. This matter went to court saying that should be an exception to the rule, and the High Court and said no, nothing doing. This needs legislative change. Very well. Now come back to very recently in 2022. There is a complete change in the law. The law says now you can not only 16 weeks, you can go for several weeks thereafter. Recently, the same Bombay High Court says, what are we talking about? Even 22, 23 weeks. It is up to the woman to decide. So this is what I'm saying, that the law changes as per the aspirations of the people and as per time. So I think even this issue of ADR in IPR for IPR should change with the times. It is certainly, please drop the word a. It is very, very much a integral part now of dispute resolution. And we know how difficult it is in courts. I mean, we've been even to mention matters. Uh, uh, before the Bombay High Court, we've been having a very, very difficult time. That we filed a writ petition, and hopefully that will get resolved. But getting matters listed on board is becoming a terrible problem for interim and ad interim. This is not the case in certain high courts like Delhi, etc. We agree. But the question is that we need a change. And that change should come more sooner than later. I'll give you another example. I mean, let's talk, for example, in the media and entertainment space. Uh, we had, I had occasion to appear in certain matters. For example, if you're a script writer, you would uh, sort of go to your association and try and register your script. I mean, this is somewhat in line with, the Writers Guild of America, where you can register your script with an association over there. So what did the court say? The court said that no, there is only you registration with an association is fine, but you have to get it if you want protection. Worldwide, you have to get it registered under the Copyright Act. So now, what does a writer do? He gets it registered with his association, and he gets it registered under the Copyright Act. If there is a dispute between a cine worker and a producer, it goes to a joint dispute, resolution committee. Now, I don't know if any of you all have even been to one of them, and I actually told the sitting judge of the Bombay High Court that I said the resolution, the dispute resolution, I said those scenarios could actually form a part of a script and a movie. I said it's absolutely hilarious. Nobody knew what was going on. It went on till midnight, and finally they said, okay, fine. I think we should now sit down together, have a cup of chai, and finish it off. So that is how issues were being resolved. So I think to set the ball rolling, I think yes, there's an absolute need. Today, time is of the essence. People are professionals in their own right, and IPR for a creative person is probably all that he has. So it's very, very important that it should be done. Over to you, Mahek.
Thank you so much, sir, for starting the panel on a right note. You have mentioned about need of ADR and how it is crucial in IPR. Before touching upon arbitration, I would like to go on my favorite topic, mediation. Mediation, of course, is all over news these days with the mediation bill pending. We have Neeraj sir with us, who's an experienced mediator. Sir, I would like to ask you about current scenario of resolution of IP disputes through mediation, and what are the challenges that we are facing at this point of time?
Uh, Thank you, Mehak, for having me over. Uh, just to put things in perspective, I have been a mediator now for 2 years, a paid mediator at Delhi High Court Mediation and Conciliation Center. But I have practiced on IPR at all levels for last 23 years. So straight away coming back to the issue in hand, which is how we can use mediation for IPR disputes. Look, insofar as alternate dispute resolution mechanisms are concerned, in terms of Section 89 CPC, which was brought in the year 2002, and mediation was at a very, very nascent stage. If I'm not wrong, the Supreme Court and MCPC, the first mediation center in India, was in fact formally notified somewhere in 2005, if I'm not wrong. So in 2002 itself, when Section 89 was brought under the CPC to give powers to a court to refer the parties to any of the alternate dispute mechanisms, which included arbitration, conciliation by virtue of the Arbitration and Conciliation Act was already in place since 1996, and mediation was also referred therein, along with the procedures under the Lok Adalat and those schemes. Insofar as IPR disputes are concerned, till about 2021, rather, perhaps only the IPR suits which were lying before the courts, they were being referred to mediation. In Delhi, we have a very effective mediation center, and almost all matters, even in district courts or in high courts, they have their own court annexed mediation centers. And in IPR matters, at some stage, I would not say that at the very initial stage, but at some stage, the parties were being referred to mediation even after, let's say, 39(1) and 2 applications were argued and injunctions were issued against one party. What has happened and a positive change which has now happened, and I remember, in fact, this at the trademark registry level, the proceedings were being referred to mediation. I think, if I'm not wrong, in about 2011-12, the trademark registry had collaborated with Delhi legal aid services, and there were certain efforts made to mediate in the matters which were pending before the trademark registry. At that stage, uh, the the experiment didn't work very well, but fortunately, with the coming of the Tribunal Reforms Act, whereby the IPAB now has been abolished, and all matters which were pending before the IPAB, which were generally appeals from the Registrar of Trademarks against in the opposition proceedings, and the rectification petitions, etc., which were pending before the IPAB, they have now been transferred to Delhi High Court. And my experience since last about 1 year in Delhi High Court is that all those matters which were pending before the IPAB, almost 3,200 matters have been transferred to Delhi High Court, which were of the IPAB Delhi jurisdiction. And with the coming in play of the IPD rules, they all are now being dealt with very swiftly. Almost all such matters are being referred to the mediation center at Delhi High Court. So therefore, today, the purview of the mediation in IPR is has been enlarged over the past 1 year, much beyond the suits. Now, at this stage, Let me just give a broad purview to our audience. In IPR, if I were to look at the broad disputes, as Mr. Mistry rightly pointed out, there are various IPRs. Today, when we look at the IPRs which have majority of litigation, that would be, I would call, the trademark has majority of litigation. Copyright also has good amount of litigation. Then there is patent litigation, which goes on for long. And because patent litigation is something that has a shelf life. A patent registration has a shelf life, and therefore the registration ultimately is to be decided in a very, very time bound manner. Then there are design matters, which include everything, not only the fashion design, which includes everything which has an aesthetic value, right from a chair till about anything under the earth. Then there are the semiconductors and the geographical indications. So leaving apart the last two, all four areas can be very well settled through the mediation processes. Insofar as the trademarks are concerned, today the potential that I see, I don't know if many of you know or not, there are lakhs and lakhs of oppositions which are pending before the registrar of trademarks. And personally, from my experience, I may say, today the oppositions in which the pleadings were completed way back in 2004, 2005 are pending for arguments on hearing. Therefore, in one of our meetings with the uh, joint secretary of the law ministry, when they were discussing the amendments in the trademark act, I had personally pointed out and requested them to consider an amendment in section 21 of the trademarks act for a mandatory mediation before you actually list it for final hearing. If I may just give a purview of what are the opposition matters, why so many oppositions. Look, under the procedures in the Trademark Act, when a party applies for a trademark and after the preliminary examination, after the registrar accepts, every application is to be published in a trademark journal, and a third party has a 4 months right to oppose it. Now, what is happening is, and the today, an opposition can be filed with a fee of 2,700 and probably the attorney fee, which may range from anything from 5,000 to 10,000. Any person who's the registered proprietor or a prior user of the mark, when he sees a similar mark, he has no option but to oppose it. With my experience, most of my clients who would oppose a mark would not actually be hurt by that particular registration if used in only that manner. But because there is an apprehension that if, let's say, it's a logo mark, but there is an apprehension that if we allow this logo mark to register, he will come close to my marks and then use it in a different manner. So people want to stop others from using or from registering that mark, and we just file opposition, which brings up the pendency before the trademark registry. The resources before the trademark registry are not as good to dispose of. I think Delhi registry has about 1,75,000 oppositions pending as on date. They do various drives wherein they are very interested to dispose of the opposition not on merits but on certain non-compliances of timelines and all. That apart, according to me, if mediation process is made mandatory for the opposition proceedings before a final hearing, then in this scenario today, with my experience, if two parties, one is seeking a registration, other is opposing the registration, if they can sit down, then according to me, some 50-60% of the oppositions can be disposed of only on some kind of undertakings by the applicant that he'll use the mark in the same manner, or he'll narrow down the registration or the goods for which he has applied, and the matters can be settled. So therefore, huge pendency on opposition sector can come down. Now, coming back to the uh, how IPR disputes can be resolved, before I move on to the suits and other aspects. Even in the rectification petition, Mr. Mistry just mentioned that there was a time when in rem matters could not be mediated. But today, if applicant files for a rectification of a registered trademark, the party may agree to voluntarily surrender that registration, or that applicant may withdraw the rectification petition. Now, the rectification of a mark is a judgment in rem, because that registration which exists with the registrar of trademark is for everyone. But at the same time, a rectification proceeding between two parties are day in and day out referred for mediation, and day in and day out we are recording settlements. I may say that today, if I have 100 mediations before me, 80 to 90 mediations that I am doing on behalf of Samadhan today are of IPR matters. So therefore, insofar as the IPR issues are concerned, I feel that time would, and once this the Mediation Act comes, ultimately we have seen right from, if I'm not wrong, right from after the CPC, we have seen the MSME Act. There is a mandatory conciliation process in under Section 82 of the MSME Act. Then in the Commercial Courts Act, Section 12A, mandatory conciliation, mandatory pre-litigation mediation has been made for commercial matters, and all the IPR matters now, unless you are seeking urgent relief, that's a different matter. That today, while seeking an injunction, parties are not going because they are seeking urgent relief. But in any case, statutory regimes are coming. I would not be surprised if a statutory regime will also come in various IPR statutes. Till that time, I would, in fact, I personally encourage my clients to go for something called a pre-institution mediation process, which is a process in several mediation centers, including Samadhan at Delhi High Court, wherein anybody can file an application if there are, let's say, oppositions pending before the Registrar of Trademark. If somebody today wants the oppositions to be mediated, the Registrar of Trademark does not refer them anywhere. There is no process as of now with the Registrar of Trademark. But if a party can file an application, be the applicant, be the opponent, before a mediation center for a pre-institution mediation, saying that there is this dispute pending before a tribunal, and we want to settle this dispute by way of a conciliation. Today, as a mediator and a conciliator, we are happy to resolve those disputes, and we have already done so. So today, the issue is that the parties have to be made aware that instead of waiting for your mark to be registered after 20 years of hearing, please apply for mediation. An applicant can always apply for a pre-institution mediation in any center. And if the opponent is agreeable, the matters can be settled, mutually convenient decisions can come. The second part of the alternate dispute resolution is arbitration. So conciliation and mediation, I don't see a difficulty. In arbitration, yes, we have not yet seen a situation wherein the suits which are being filed before courts for infringement of copyright, trademark, or patents, they are being taken to arbitrators for a decision. Now, obviously, because most of these suits fall from the stranger matters wherein there are no agreement between the parties, but some of these suits, including suits between families or family members, wherein a trademark is in dispute, there may be an arbitration clause in the partnership deed or the dissolution deed. So the parties can always, even for the trademark issue, come before an arbitrator. In the suits which relate to the erstwhile distributors, the distribution agreements, we always encourage our clients to have an arbitration agreement. If the distributor, after the termination of the distribution or the franchise agreement, is continuing to use the trademark, it can go before the arbitrator, and those could be time-bound remedies. Similarly, there is no bar if parties who have gone before a particular court, and I'll take liberty to say this. If two parties today are litigating before a court which is not an IP savvy court, we always hear that Delhi is a very IP savvy jurisdiction. We just heard from Mr. Mistry that Delhi High Court, we file a petition today at 12 and we have a hearing tomorrow at 10:30 a.m. If it is very urgent, sometimes at 12 we file it and the hearing can be listed at 3 p.m. or 4 p.m. in the Delhi High Court. That's how we can have matters listed. But all across India, the same is not the situation. In those cases where the judges are not IP savvy, where two parties are already litigating, a suit has been filed, the parties can always, after the filing of the suit, get into an arbitration agreement and transfer their dispute to, let's say, whosoever is IP savvy in their jurisdiction and get it resolved through a mediator or an arbitrator in their proceedings. Arbitrator, they can always seek a judgment on merit, which dispute can be resolved in 6 months. So, so it is. I think time has come, and obviously the government is working, the legislature is working, the Supreme Court and the High Courts are working towards it. I will not be surprised to see a time when everybody, and as a lawyer, it is not that lawyers would suffer any loss. There was initially, 2005, 6, when the mediation centers were being set up in the courts, there was huge oppositions from lawyers. But ultimately today, being a mediator and as a lawyer who has practiced on IP side for last 10, 12 years, I think I've got more than 100 matters settled on behalf of my clients as not as a mediator but as a lawyer. The ultimately the happiness that you see on the faces of both parties when they go out and when the settlement agreements are signed has given you much more satisfaction than you get when you get a favorable judgment, which you always tell your client that, okay, this is a judgment, but this is subject to an appeal before a higher court. So tomorrow you may have to come back to a. When we say goodbye to our clients or as mediator to both the parties, from a mediation room with a settlement agreement, the happiness that you see at their face, that is something that I cherish. And therefore, mediation is the way forward. For IPR matters, I think that post the Tribunal Reforms Act today, almost everything, and let me say this, in last about 1 year in Delhi High Court Mediation Center, I may have settled about 25 to 30 disputes. One issue is that being a domain expert, what helps is that when you are settling dispute, one can always suggest from your experience of 20 years as to look in one matter 15 years back, this was the settlement we reached, and there are innovative settlements which are coming. I would not take names, but there are matters in which we have settled as in, okay, for next 3 months you'll do this, for next 3 months you'll do this, and there is a very smooth transition. What generally happens in trademark or copyright matters is that there is no transition. An injunction comes, the party has to stop its use. In mediation, both the parties, there is no injunction, both the parties can actually decide on a smooth transition of the trademark. So today we say that, okay, in 3 months, you will only remove the particular logo aspect. Then in next 3 months, you will shift your mark. You will be entitled to tell to the public something like in the Hindustan Liver matter of Fair and Lovely, and they have shifted to another mark. They have had time because there was no injunction. They themselves shifted because of the general issues. So today they had time to tell the public that Fair and Lovely is now Glow and Lovely. Similarly, in trademark matters, the mediation and the conciliations can help parties for a smooth transition from one conflict to the other. And my experience has been that if you give timelines to parties to have a smooth transition, no businessman today wants to get into larger disputes. I just settled a dispute between two large multinationals in FMCG matters, wherein if that dispute would have gone to court, it would have been huge expense for both the parties. Both parties would have got at least the super seniors in the matter and spent crores of rupees on this litigation. But in a PIM before the Delhi High Court Mediation Center, we settled this dispute on packagings. So therefore, I see immense possibility in IPR matters on the disputes. The right way and right statutory support is required, but that apart, it's a all win-win situation for everyone. Over to you, Meg.
Thank you so much, sir. I think you very beautifully explained how mediation is working, and of course, what is the scenario in Delhi and what are the challenges, and how mediation, of course, it's a win-win situation, and your experience. Now, my next question is to Amit sir. It has been mentioned that, of course, Delhi High Court is a IP savvy court, and there's a lot that we read about IP bench, which is that it's very active. Similarly, when we are talking about ADR, there are some jurisdictions which are very proactive. Delhi is there, Bombay is there, maybe Hyderabad is there. But talking about the country at large, talking about all the jurisdictions, we would like to understand the challenges that we are facing at present in making ADR more effective for resolution of IP disputes. Over to you, sir.
Good evening, Mehak, and everyone, all the participants. My co-panelist Neeraj ji has already covered a lot of grounds. What I felt that I could add on to it, he has already concerned for IPR as right for soon shall be looking at an amendment in the statute where, just like Commercial Courts Act, we should be having a pre-litigation or a pre-institution mediation akin to the sections therein. A pre-institution mediation goes to the Legal Services Authority, whereas we in the Delhi High Court, being the pioneers where the mediation was taken away from the bench, and it was so put forth that we as lawyers, as practicing lawyers, can also handle the entire situation well. Because it would also, as was being put forth, that some of the benches may be, and I'm talking not just confined to the Delhi High Court, some of the benches may be IP savvy, some of them may not be IP savvy. Keeping that in mind, yes, now when the Delhi High Court provides for mediation, Samadhan, of which both me and Neeraj are members, there is a huge change in the entire scenario as what, because the basic criteria of when we offered that we as lawyers can be mediators, having an expertise in the subject and also being an open to both the sides, rather than coming from where the judges would continue to maybe pass a judgment if not a settlement. Be that as it may, the jurisdictional issues qua the entire country has been asked to me by Mehak. There have been that is a topic which at the moment is quite open. I've myself been opposing in many forums qua how would the jurisdiction be entertained, how much of a application of the Civil Procedure Code would apply. And with the new passage of all the judgments that we have, coming back to why ADR, mediation as a forum. Hello.
I think sir is facing some network issues. Okay, in the meantime, sir joins. Jamshed sir, I would like to ask you one question. There has been a lot of discussions on mediation, pre-litigation mediation, and how mediation, of course, is a very promising mechanism to resolve disputes. But let's talk about arbitration. You are a central council member also at ADR Bar, and there is a lot of discussion on making India as a hub of arbitrations and bringing international arbitration and whatnot. IP, of course, is a ever-growing field, and it is imperative to understand role of arbitration in IP disputes, how we can make it more robust and how we can make it more effective.
So yes, I think India as a arbitration hub is something that I think we've always wanted. We've yeah, with the greatest respect, I think we've sometimes, especially our the larger clients have always suffered in the sense that if the arbitration was in Singapore, Paris, London, or maybe New York, they've had to sort of engage appropriate barrister attorney in that jurisdiction, and it always turns out to be frightfully expensive for that. And then of course there was that whole issue about bias that for some reason, if it were high court arbit- high court sort of approved arbitration centers, then there was a certain international bias that came into play. But I think slowly all that is changing, and I think uh, I mean, with centers like Dubai and others, I think, and even other smaller countries around the world, they've also done very well. And I think India as a hub, I, I mean, there's no question that we are, sort of potentially probably one of the best, and with systems that should be in place. I think we are reaching sort of certain levels. I must just add one my favorite topic that we've had a huge issue about, and people like Ajay Thomas and all of them have sort of spoken to me in detail that we need you know cheaper transcripts that should be made available for international arbitration, especially for India. I think technology is going to change all that very soon. Uh, I think coming to your next question of role of arbitration in IP, sometimes when you go through certain contracts and you find there are in-house counsel of production houses and others who've been kind of opposed to the system of having an arbitration clause, as in if there's a dispute between, say, an actor and a production house, and one has always tried to explain to them that, look here, if you sort of go the court route, it will you know you may be sort of stronger in a sense, wherefore you can get uh, a senior lawyer to argue for you and get an injunction and things like that. But at the end of the day, are people, whether it's a judiciary or otherwise, are they actually sort of uh, you know I'm sorry to use the word, knowledgeable enough to actually address these issues and concerns, especially whether there are technical aspects involved in it. I mean, whether it is construction law or so many other aspects. So the for that, and IPR does form a huge part of. Quite often, it is I'm not getting recognized, or you've taken over my IPR. There could be a whole of a load of issues which can be happily sorted out. Uh, I completely agree with both Mr. Grover and Amit that sort of pre-institutional mediation must be there. It must sort of uh, be the precursor to even arbitration, and even in arbitration, let the arbitrator also take the parties into confidence and first try and sort it out. If it is not possible, then very strict timelines, And also the other aspect which I want to bring in here is the concept of ODR. I mean, why can we not have ODR, where, how does it matter? You can get lawyers from around the world joining in, because in arbitration it's fine. You can get international lawyers in for arguing their respective cases, and that'll help. I think in every way. I think we need sort of uh, very quick training. This training actually should happen in my respectful submission, starting right from law college time. Just as you have moot courts, we must have moot ADRs, and that's something that should form a part of the law syllabus. And they should be, because as a lawyer, your skills can be honed in all these different formats. So I think so to answer your question in a nutshell, I think it's absolutely essential. There are so many disputes which needlessly go to court today. I think there are issues of which are confidential. There are a lot of amounts that are involved. I mean, we know that internationally, even the largest dispute can be resolved. And in fact, how often we tell the court that these are issues that shouldn't be coming to court. They should go, to dispute resolution. And then you find on the second date of hearing, yes, Mister, what you're saying is right. I think I'll refer it to mediation or arbitration. So I think that is essential. And I think you know we intellectually we're very, very good, very strong. And I think as lawyers, this is a wonderful branch and method of the law. So I mean, I really encourage the students who are listening in to take this up, because this is very much the future.
Thank you so much, sir. Thank you so much for your suggestions, specifically with ODR and how technology is evolving and how it can be used in ADR as well. My next question again is to Neeraj sir. You've talked about how mediation purview has been enlarged and specifically about Delhi also. But there are, of course, a lot of discussions that there is lack of trained mediators in India and so many other things that come to discussion, why we are lagging behind. How can the Indian legal community promote use of mediation, specifically for resolving IP disputes, and what steps can be taken to ensure that parties are aware of the benefits and possibility of this mechanism? Of course, we are talking about Delhi, Bombay. They are very proactive, awareness is there, but there are various jurisdictions where people are not aware. Over to you, sir.
Look, according to me, we have had, in fact, those of us who are now declared as trained mediators, we have had 40 hours training sessions, extensive sessions over 3 days. And when one enters into those sessions and when one gets out after that 40-hour training, as lawyers, our whole purview about mediation changes. Now, that obviously depends on a particular lawyer across the country as to how mediation is the way forward. According to me, uh, look, the mediation centers all across the country are maybe not that active, because either they are not being run in active participation with the local bars. As Amit was mentioning, in Delhi High Court in 2007-8, when for the first time Samadhan was propounded, it was the bar from Delhi High Court itself which came forward and which said that we will run it. Today, the center is being run entirely by the bar. The coordinators, the mediators, we have almost 250, 300 trained mediators in the center with domain expertise. Like I personally have a domain expertise in IPR matters. So the coordinators refer IPR disputes to me, because for me it is easy to understand. I don't need to go into the law. For me, in the first meeting, I can understand and I can, get on where what is the pain point for the parties and how this can be resolved within the purview of the act and what all various remedies can be there. So similarly, I would say that one, the domain experts from all areas should be available as mediators. Second, the bar all across. I am, I am nobody to guide the judiciaries all over India, but only a suggestion that even in the district courts in some state or in some small town, if the local judiciary under the guidance of the High Court can involve the bar much more than it is involving for running effective mediation centers there, in consonance with the fact that these trainings, it is not something that, look, today, let me say this. Today, in Delhi High Court, the procedure to become a mediator is that whenever the applications are open, they call for applications, and then there are rounds of interviews pursuant to which they choose people who are to be trained as mediators. Though I have used the same procedure and become a mediator, but at the same time, according to me, uh, some kind of training sessions should be given irrespective of these interviews. Anyone who's interested to become a mediator, the training sessions could be given, and then later on, whether you want to continue them with your mediation center or not, or what kind of matters you wish to mark them, because obviously I believe that the center wishes to funnel down the applications received so that they can maintain a quality of drafting. Look, ultimately a mediator, after you have made a settlement, is also required to do accurate drafting, a drafting of a settlement agreement which is not vague in any manner, should have appropriate experience so that 6 months after the settlement, the parties do not get back to a court saying that we did not think that this could happen, and that can only come through experience. So therefore, all those aspects are seen in those interviews, and then appropriate people having appropriate experience and skills are taken into mediation. But having said that, I think if basic trainings are given to lawyers, it is the lawyers who communicate the aspects to their clients. Now, sometimes, not always, sometimes we get lawyers who are not very open minded towards mediation. So, ultimately, that may be a bar, but without getting into the issue as to whether lawyers should oppose this or not, I would say that anybody who knows the benefits of mediation would not oppose it. It is not that by entering into a pre-institution mediation, I lose a litigation. It is I win that client. That client actually appreciates that where I could have filed a suit straight away and, let's say, taken a 10 times fee that I had taken for a PIM, the lawyer guided him to a PIM, and ultimately he came out with the same solution that he would have got in the suit. So therefore, it is all upon, and ultimately, it's. I would always say that bar and bench are two sides of the same coin. So therefore, it is the positivity has to go around. Perhaps the judiciary also has to encourage parties to at least go once for mediation in a timely manner. There is also an aspect involved that sometimes the parties don't agree to mediate, to say that no, because if we go to mediation, it will take 6 months and the other party will keep on enjoying. So therefore, timely mediation, counseling of the parties, preliminary counseling when the suits are filed, even if the pre-institution mediation is not mandatory till that time, it goes a long way. Cases in which the judges themselves say in a very polite manner that you go there, you discuss. Look, ultimately, many parties do not know that what we discuss in the mediation rooms is absolutely confidential. In many disputes, the disputes which can be read on black and white in the pleadings is not the actual pain point of the parties. The actual pain point of the parties lies somewhere else. It is only the black and white which the lawyers have suggested them. So when they go to mediation rooms, they can actually resolve their actual pain points instead of the allegations which they have written on, and this will never be disclosed. So if the mediation ultimately today, if a mediation discussion does not lead to a successful settlement agreement, the offers and counter offers cannot be relied upon by any party. And this is the benefit of going to an institutional mediation. If you go to somebody only as a panchayat, then perhaps there are no such people record, people then later on rely upon. But in institutional mediations, this is a very strict rule which is conveyed to the parties. And look, ultimately, it is the parties who are to be counseled. Even in matrimonial matters, today, whosoever, and we all lawyers, today, matrimonial matters, 138 matters, they often, we get the request for advices from our own relatives. We as lawyers, at the very first instance, if we start telling them that, look, before you go for a 498 or before you go for a divorce proceeding, according to me, try a pre-institution mediation, maybe everything settles. My personal experience has been that whosoever has come over to me, I'm not a matrimonial lawyer, but if I have suggested them and they have gone for a pre-institution mediation in a matrimonial matter, they have after 2 months come over and thanked me. That thank you for guiding us, because if we would have gone into the divorce matters, we would have washed our dirty linens outside in the courts. And in matrimonial matters, we all know the masalas come only when you reach a lawyer's chamber. So those masalas, there's no point in using those masalas. Please first go for a simple sober meal without those spices. If you don't, if the parties cannot, digest that simple sober meal in a mediation center, then the parties will always face, and then they can come back at any point in time after washing their dirty linen. But in a mediation, you don't wash any dirty linen. Everything is kept apart. We only look at future. And that is how it all works. So ultimately, in every jurisdiction, and as I was mentioning, arbitration in IPR matters is a very good alternative for the jurisdictions in which the courts are not IP savvy. The parties can always, in civil matters, the parties cannot, by way of an agreement, give jurisdiction to a particular court. So if Delhi does not have a jurisdiction, parties sitting in let's say somewhere in Madhya Pradesh cannot come to Delhi High Court without a cause of action. But by way of an arbitration agreement, they can always say that let our dispute be decided by, let's say, Delhi International Arbitration Center, which is an arbitration center under the aegis of the Delhi High Court. The Delhi International Arbitration Center will have arbitrators on their panel who are well equipped with IPR disputes. That particular dispute, which may linger on in a court for 10 years with parties hanging fire on a bridge as to who would win, can ultimately be decided in Delhi International Arbitration Center with the schedules, the fee as per the fourth schedule, which is one of the lowest in the country, and with effective judgment in whichever party's favor. So ultimately, lingering on of a case is not helpful to anyone, and we, as part of the system, it is our duty to advise our clients not to go for longest litigation and to advise them about these areas. The moment lawyers become positive about it, I am very sure the systems will change, and we are looking at, and ultimately, look, today we have not reached a stage where the mediators like us are paid. We are doing it as social service to our respective courts. But a time will come, which has already come in some jurisdictions, when mediators are highly paid. They are the effective mediators. They are independently practicing mediators. So it is altogether an independent profession. So if you can gain those skills of a good mediator, you will be as highly paid as a counsel in the court. So times will come, and yes, I am very hopeful that with the enactment of the mediation bill, things will definitely change.
Yes, thank you so much, sir. And what I have gathered, of course, from it was a very insightful session. But what I've gathered is that future is very bright when we talk about ADR in IP disputes. And
Look,
there's
I would not say. I mean, it's bright, but yes, we have to work towards it, and it is not that ultimately to bring out the clogging of our judicial system. You may talk of trademark registries, you may talk of the IP offices, you may talk of the high courts, the district courts. This is an effective mechanism to actually let those courts decide only matters in which things cannot be decided. Look, there are matters wherein there is no resolution that we can find. Sometimes some disputes come to us in such matters wherein, even as a mediator, we don't find a midway. We either have to tell a party to withdraw the suit or the other party to suffer a decree, which, according to me, is not the right way. In a mediation, something has to be given, something has to be taken. So sometimes there are disputes in which, on the first day, unfortunately, we have to say that, look, it seems there is nothing possible. And therefore, an adjudication by the court is required. But the court should be burdened with only such disputes in which there is no midway required, there is no midway possible. So I would not call it a bright one, but yes, I think time would come when, as ADRs, the arbitration, mediation, and conciliation would become three wheels of a four-wheeler car, of which the courts would be the fourth wheel. So ultimately, it would be a car which would run on four equal wheels, rather than this being called as the smaller wheels on the other side and running with a tractor. The large wheel, the courts at the moment are running as a tractor with the two large wheels, and these front small wheels of a tractor are the wheels of ADR. The time would come that when the justice system would be riding on a four-wheeler car than a tractor.
right. Uh, this has been very beautiful, but beautifully explained, sir, as to how ADR should be and what it is at this point of time. I would like to thank you for explaining everything really well and giving your personal experience. I'm very sure that with people like you, it will be mediation per se would be very is going to be the future, of course, for resolution of disputes. Jamshed sir, would you like to give your concluding remarks before we end this session?
No, I think I kind of agree that the approach has to be, well, if I can borrow what Mr. Grover said, slightly cautious, but definitely hopeful. I think there is no two ways about it. I mean, we are looking at you know see, as the world grows smaller, and you would find sort of more and more, and I really I thought one of what he said, that you can become a top international mediator, and they can resolve disputes in a couple of days, and so there's the point of that is that there is nothing which is cannot be resolved. And I think that's a very important, I mean, especially in the large commercial disputes. I mean, if that can be resolved in 2-3 days, then I think our court system is so archaic. One area, of course, which I kind of slipped, didn't talk about was, with the cryptocurrency and these other areas of the way technology is going. And in all these, I mean, whether the countries recognize them or do not recognize them as legal or otherwise, if you people are investing in all this, they need, so technology and resolution of issues, I think that's such an important area. I mean, the only I mean, you had WIPO, which had domain name disputes. I think we probably need now a worldwide sort of dispute resolution, and if ADR can be that, and India can be the hub or something like that. Can you imagine, uh, uh, what a bright future. I think the government should take note of what we are saying here very seriously.
Absolutely, sir. And I think having such discussions and doing such sessions, of course, sends out a message. I'm really grateful to our panelists, Neeraj sir, Jamshed sir, and Amit sir, of course, had to drop out because of connection problems. It was a really insightful session, and there's a lot that I have.
Before you close,
Yes, sir.
if there are any questions of the audience, we can take quickly in 1 or 2 minutes or 3 minutes if anybody has a question.
Okay. If anyone has a question, they can send in their questions. I can address it to the panelists. We can very quickly take the questions because, sir, we have another session also starting.
No issues,
Yeah.
because it was there. So I thought if
Yes,
anybody
yes.
is,
If anyone has their questions, they can send it out in the chat box. Firms for ADR, somebody is asking. There are so many firms which are working on ADR. You can check out, almost all the firms have their dispute resolution practices. Anyone?
in fact, I must say there are private setups or there are setups apart from the court annexed mediation centers these days, which work on fee basis. So there are setups which have been set up by mediators as professional mediators. So the parties could also approach them. But obviously, till the time there are alternative setups in the court annexed mediations, which at least the court referred mediations are cost free for the clients. Almost all of the costs are borne by the courts and the centers.
Right, sir. Any questions? Any more questions? Okay, there's one more question regarding mediation on online mediation per se, because arbitration, of course, Jamshed sir mentioned, can happen online.
I will take that. In fact, I think I missed one of the successful features of Samadhan today is that we are doing mediations by VC, and that helps for the reason that over the last 6 months, I have settled matters in pre-institution mediation, the copyright matters of huge companies with software copyright claims in PIMs, wherein the parties are sitting in Gujarat, they are sitting in Hyderabad. We enter into sessions by the software set up by the Samadhan. We have in that software, in a similar meeting, we have options to keep one party in lobby till the time we are in caucus with one party, then keep the other party in lobby till the time we are in. So in those mediation centers, apart from the tea and coffee, which we offer to our parties when they are in physical mediation with us in the Delhi High Court mediation centers, apart from tea and coffee, we offer everything that we offer in the mediation. So we only ask the parties to have their own cup of coffee while we discuss it, so that the mediation is informal one. And because we encourage parties to discuss it in a very, very informal manner. So I sit on the same chair that I am right now sitting, with the same tab almost daily. After the court hours, I am into the Samadhan video conference mediations, and that helps because let's say if there is an opposition, no party would travel, from Hyderabad to Delhi with a ticket cost of 15,000 to attend a mediation session. But the moment we tell them that, look, you don't need to come here, just join this link. We'll send you a link on the mediation, and just if you are happy with the resolution, please enter into a settlement agreement. If you are not happy, then you only see my face, which is not that bad to see, and we'll just discuss, and you can ultimately decide not to pursue it.
Right, so that's amazing if it's working really well in mediation and arbitration. Of course, ODR is also a way forward, and there's a lot of challenges which are there with technology, but it also proves to be beneficial in ADR per se. And thank you for highlighting a need of ODR and how it is working so well. Thank you so much. If there are any more questions, you can write it to us, and we will be happy to address it little later to our panelists so that they can answer that. Thank you. I would like to thank our panelists and the participants for joining in today. It was an insightful session, and we look forward to hosting you again and again.
Thank you. Thank you so much.
Thank you, sir.
Thank you.
Thank you, Jamshed, sir.